Excellences, chers collègues, Mesdames et Messieurs, je suis heureux de vous accueillir ici aujourd'hui pour l'ouverture du siège à La Haye du mécanisme pour les tribunaux pénaux internationaux, communément appelé mécanisme. Excellencies, colleagues, ladies and gentlemen, I am delighted to welcome you today to the opening of the Hague branch of the International Residual Mechanism for Criminal Tribunals, commonly known as Mechanism for International Criminal Tribunals, or simply the mechanism. I would like to extend a warm word of welcome to the Minister of Security and Justice of the Netherlands, Mr. Ivo Opstelten, and to the Mayor of The Hague, Mr. Josias van Aartsen. As our host state, the Netherlands has long played an invaluable role in facilitating and supporting the work of the ICTY, and I look forward to an equally strong and productive relationship between the mechanism and the Netherlands in the years to come. As for the city of The Hague, Mayor van Aartsen has not only been taking steps to make the collection of international courts and other international institutions based here more of a community, but in introducing this community of extraordinary institutions to the world at large. I would also like to thank my fellow principals of the mechanism, Mr. Hassan Boubacar Jallo and Mr. John Hocking, for being with us today. I am also grateful to Mr. Serge Brammertz, the long-serving prosecutor of the International Criminal Tribunal for the former Yugoslavia, for joining Mr. Hocking and me in marking this occasion in our roles as representatives of the tribunal. And I would like to acknowledge the presence of my valued colleague, Judge Van Johansen, President of the International Criminal Tribunal for Rwanda, who is also with us today. As for our keynote speaker, I am honored to welcome Mrs. Patricia O'Brien, Under Secretary General for Legal Affairs and the Legal Council of the United Nations, who is joining us on behalf of the Secretary General. We were very fortunate to have Mrs. O'Brien with us just a few weeks ago to mark the 20th anniversary of the ICTY. And her return today is not only a sign of her own deep and abiding commitment to the rule of law and to the work of international criminal tribunals, but also to the commitment of the Secretary General himself in this regard. Mrs. O'Brien has been a strong supporter of our work, and I am very glad she is with us today. Finally, I wish to pay special tribute to the judges and staff of the ICTY, the ICTR, and the mechanism, who are with us here today to mark this special occasion. Without the tireless efforts, tremendous talents, and keen sense of commitment of those of you who serve at the ICTY and the ICTR, none of the work of these first two pioneering international criminal courts would have been or would continue to be possible, as the mechanism assumes responsibility for core functions of the ICTY today. As it did a year ago with respect to the ICTR, it is important to acknowledge that the legacy that it will take up is very much the legacy that all of you and those who came before you helped to create. It is a legacy of which all of us should be and are very proud. I thank you all for that, what you have done, and all that you will continue to do in the future. And I am very pleased to welcome to the podium our very first speaker, the Minister of Security and Justice of the Netherlands, Mr. Ivo Opstelten.
President Tonka, Madam Under-Secretary General, and President Song, Your Excellencies, and especially, of course, President Meron, Prosecutor Brammertz, and Prosecutor Boubacar Jallo, and Register Hocking, and ladies and gentlemen, distinguished guests. Welcome to the official opening of the Hague branch of the Mechanism for International Criminal Tribunals. There's a good reason why it is located in The Hague, Mr. Mayor. This city hosts 131 international organizations and institutions in the field of peace and justice. And that's why it is known as the legal capital of the world. Today we are the guest of the International Criminal Tribunal for the former Yugoslavia, which has made a major contribution to The Hague's reputation as a city of peace and justice. The ICTY was established here 20 years ago, and since then The Hague has been chosen to host other international courts, such as the Special Court for Sierra Leone and a Special Tribunal for Lebanon, and of course the International Criminal Court, which is also based here. To the Dutch, this is no surprise, because for centuries and with great foresight, we have been calling The Hague Hofstad or Court City. The work of those initial ad hoc tribunals has not always been easy, but they send a powerful message. Anyone who commits international crimes, wherever that may be, will sooner or later be brought to justice. Trials of people indicted by an international tribunal are often highly complex, and it can take many years to conclude such cases and deal with the aftermath. So I am pleased that the MICT has been set up to take over all the residual tasks of the tribunals, such as trials of fugitive and indictees, handling applications for review of a final judgment, and dealing with the request for pardon, along with ongoing witness protection programs and managing the archives for academic and case law purposes. In other words, it will tidy up loose ends and provide redress in all kinds of ways. Your Excellencies, ladies and gentlemen, it was exactly 1 year ago today, on the 1st of July 2012, that the first branch of the mechanism was launched in Arusha, Tanzania, to deal with the aftermath of the International Criminal Tribunal for Rwanda. And as the Dutch Minister of Security and Justice, I am very pleased and proud to launch the second branch here in The Hague. This branch, Mr. President, will focus on completing the work of the ICTY. Over the past 20 years, the Dutch government has done everything possible to enable the ICTY to operate independently, safely, and effectively. My own ministry plays a key role. We are responsible for a variety of tasks to facilitate the tribunal's work, ranging from transporting and accommodating suspects to providing visas for anyone who has to travel to The Hague in connection with the trial. We also protect witnesses, ensure their safety, and so on and so on. We look forward to performing the same task for the MICT, so that it can bring the activities of the ICTY to a proper conclusion. Needless to say, ladies and gentlemen, Your Excellencies, the fight for global justice is far from over. Unfortunately, there are still numerous flashpoints where, day in, day out, international crimes are being committed. So our fight for justice will continue. And every state has a responsibility to ensure that those suspected of international crimes appear before a court. If possible, of course, before a national court, after a regime change in the country where the human rights violations occurred. This can make a major contribution to reconciliation. But as we all know, this is not always possible. And that is why international courts remain a vital necessity. Countries where international criminals take refuge also have a responsibility. They need to track down suspects and hand them over to the country or court that is going to prosecute them. If this is impossible, those countries must be willing to bring suspects to justice themselves. And the Netherlands is fully aware of its own responsibility in this area. Special teams in our National Crime Squad and Public Prosecution Service investigate and prosecute those responsible for international crimes, not only suspects from other countries who are living in the Netherlands as asylum seekers, for example, but also Dutch people suspected of international crimes. We will continue this successful approach. We are now working with Belgium and Slovenia to improve agreements on extradition and mutual assistance in relation to international crimes. Those who commit such crimes need to understand that they will never find a safe haven. Ladies and gentlemen, all this demands close cooperation with other countries and international organizations. So I am very, very happy that today, with the launch of the mechanism for international criminal tribunals, we have taken another important step on the road to justice. Thank you.
Thank you very much for your remarks, Minister Opstelten. We very much appreciated them. Our next speaker on today's program is, of course, our host at The Hague, the Mayor of The Hague, a long-time supporter of the ICTY and of international justice, the Mayor of The Hague, Mr. Josses van Artsen. Mr. van Artsen.
Mr. President, Madam Undersecretary, Your Excellencies, ladies and gentlemen, on the 9th of December of 1948, the Convention for the Prevention and Punishment of Crime of Genocide was adopted by the United Nations General Assembly. That convention would probably not have come about without the ceaseless efforts of Raphael Lemkin, the man who had first coined the term genocide a few years before. And despite many war criminals being brought to justice during the Nuremberg and Tokyo war trials, it would take nearly half a century before the world had an institute with the authority to address crimes against humanity, including genocide. The television images of prisoners in the Omarska concentration camp were broadcast around the world in the summer of 1992, creating massive shockwaves. The following year, the International Criminal Tribunal for the former Yugoslavia was founded. This magnifique aventure morale et juridique, as pioneers Jorda and the late Antonio Cassese described it, was certainly not easy at first. The ICTY lacked resources, particularly money and government support. However, it had in Secretary Albright a minister at its side, and she and others managed to persuade Boutros Boutros-Ghali that the failure of the ICTY would mean the failure of the international community. Fortunately, this, and of course you can say this did not happen. And at the same time, the foundation of the ICTY and later on the ICC proved that the Genocide Convention was more than a paper tiger. Now, 65 years after the adoption of the Genocide Convention and 20 years after the foundation of ICTY, we are present at the opening of the Hague branch of the Mechanism for International Criminal Tribunals. Here in the city, which in the 1990s has become, as the Minister of Security and Justice already said, the global center of international criminal law. This gives the city great pride, but we are actually aware of the need to justify that name each and every day, and we will continue to do our utmost to fulfill the role of international city of peace and justice to the best of our ability. What, Your Excellencies, ladies and gentlemen, makes international criminal law special is the fact that it affects individuals, people individually. Everything is about people, both crime and retaliation. And when the last witness has died, her or his evidence must be preserved for future generations. And the city of The Hague feels it as a duty to contribute. Thank you very much.
Thank you very, very much, Mr. Mayor. I now call upon Mrs. O'Brien, Under-Secretary General for Legal Affairs and Legal Counsel of the United Nations, for her keynote address. Mrs. O'Brien.
Mr. President, Mr. Minister, Mr. Mayor, Excellencies, ladies and gentlemen, it's a great pleasure to be here once again and to speak to you on the official opening of the Hague branch of the International Residual Mechanism for Criminal Tribunals, otherwise known, as we all know, as the Residual Mechanism. The opening of the Hague branch marks a crucial milestone in the transition from the ICTY to the Residual Mechanism. Once again, I'd like to pay tribute to the Netherlands and to the City of The Hague for their significant contribution to international justice. By hosting so many international courts and tribunals, and by facilitating their activities, the Netherlands has positioned itself at the forefront of states supporting the advancement of international justice, including today at the opening of the newest addition to the landscape of international criminal justice. I'll take the opportunity today first to reflect upon some of the developments and achievements of the past 2 decades in international justice, particularly those of the ICTY and the ICTR. I'll then highlight some of the most important features and functions of the residual mechanism, which serve to demonstrate the vital role which it'll play. At this juncture, and with the benefit of the ICTY's 20 years' experience in delivering international criminal justice, it is also appropriate to consider some of the challenges which the mechanism may face as it carries out its work. As the experience of the ICTY and the other international and UN-assisted criminal tribunals has demonstrated, some challenges will be specific to the institution, while others will stem from the nature of today's system of international criminal justice. Today's system would be unrecognizable to a jurist of the early 20th century. In the immediate aftermath of the horrors of the Second World War, the Allies brought to justice, through the Nuremberg and Tokyo trials, those who had committed atrocities. The international community sought, in the 1948 Genocide Convention, to ensure that the horrific events of the Holocaust were not to be repeated, and created, in the Geneva Conventions of 1949, a legal framework to regulate the conduct of war. In the years between the Second World War and the conflict in the former Yugoslavia, the Geneva Conventions and the Genocide Convention essentially lacked any political enforcement or practical enforcement. Those who acted in violation of their provisions were not brought to justice at the domestic level or elsewhere, except in one or two war crimes cases. These exceptions were so unusual as to seem to prove the rule of impunity. The establishment of the ICTY and ICTR in the early 1990s demonstrated a newfound and serious commitment on the part of the international community that those responsible for perpetrating the most serious crimes of international concern should be held accountable. As the ICTY and ICTR draw close to completing their mandates and transitioning to the residual mechanism, we do well to reflect upon some of their most significant achievements. First and foremost, many of those most responsible, including individuals who once operated at the highest echelons of political power and influence, have been held accountable for serious crimes under international humanitarian law, which were perpetrated in the conflicts in the former Yugoslavia and Rwanda. The proceedings of these tribunals have demonstrated to the international community that although justice may take time, no one is above the law. Secondly, the establishment and operation of the ICTY and ICTR breathed new life into the system of international criminal justice. In the years following the establishment of those tribunals, we witnessed the creation of the Special Court for Sierra Leone, the extraordinary chambers in the courts of Cambodia, and the Special Tribunal for Lebanon. The ICTY also acted as the catalyst for the negotiation and conclusion of the Rome Statute, establishing the ICC. Efforts to develop a code of international crimes and a permanent international criminal court had been ongoing for some decades. The ICTY's demonstration that an international criminal tribunal could work in practice has enabled the ICC to come into being. Thirdly, the ICTY and ICTR have made some monumental contributions to substantive and procedural international criminal and international humanitarian law. Their judgments have dealt with such important matters as the legal criteria for distinguishing between international and non-international armed conflicts, confirming that the application of many rules of international humanitarian law extends to internal armed conflict. They have clarified the elements of offences such as enslavement, rape, and torture, and have greatly advanced jurisprudence in the field of gender crimes, an area largely undeveloped by the Nuremberg and Tokyo tribunals. In many areas of substantive international criminal law, they have built the foundation on which other tribunals have subsequently built. The ICTY and ICTR have also played a crucial role in the development of international criminal procedural law, bringing together elements from civil and common law. In this field, the tribunals essentially had to start from scratch, developing procedural law to address vital issues, including the rights of defendants, rules of disclosure and admissibility of evidence, victim and witness testimony and sentencing, plea agreements and assistance to national courts. This body of procedural law and practice forms part of the legacy of the ICTY and ICTR as they transition to the residual mechanism. I'd also like to take the opportunity today to highlight more broadly two of the most significant effects of the development of the last 2 decades in international criminal law. Firstly, we have seen a gradual domestication of the norms of international criminal law. The rich body of case law and accompanying verdicts and sentences handed down by the ICTY, ICTR, and other international criminal courts and tribunals have made real protections which were effectively, previously, only theoretical. These courts and tribunals are, however, courts of last resort, and indeed in the statute of the ICC, we find enshrined the principle of complementarity and the primacy of domestic jurisdictions. States are expected to prosecute before their national courts those who have perpetrated atrocity crimes, and it's only where a state is unable or unwilling to prosecute that the ICC will step in. The system of international criminal justice relies first and foremost, therefore, upon member states taking responsibility for promoting and ensuring accountability at the domestic level. States must, and increasingly do, play their part in seeking to ensure that their own courts and prosecutorial authorities are able to exercise jurisdiction over serious international crimes in a full and meaningful way. Secondly, I think that we've seen a significant shift in the nature of the discussion which takes place within the international community in the face of situations in which grave international crimes are committed. Sadly, such situations persist in our world today, and atrocities continue to be perpetrated against civilian populations. However, although it may take time to bring perpetrators of international crimes before a court, be that at the domestic or at the international level, in the statements now of world leaders, in the work of journalists, and in the expressions of public opinion, accountability is a pervasive theme. We hear expressions of outrage, not only at the perpetration of atrocities, but at the idea that those responsible could ever or should ever enjoy impunity. I see this change in discourse as evidence of an irreversible shift towards accountability. And I'm in no doubt of the vital role which the ICTY and the ICTR have played in bringing this about. The images of senior political leaders in the dock have had an enormous and palpable effect beyond the courtrooms in The Hague and Arusha. A message has been sent and an expectation has been generated that those who would perpetrate such crimes will face justice. The Security Council, in the preamble to Resolution 1966, establishing the residual mechanism, reaffirmed its determination to combat impunity for those responsible for serious violations of IHL. And they emphasized the necessity that all persons indicted by the ICTY and the ICTR shall be brought to justice. In establishing the residual mechanism, the Security Council made clear first that the conclusion of the mandates of the ICTY and ICTR must not result in impunity. And secondly, that a commitment to procedural fairness and the rights of accused and convicted persons must be maintained. Both of these elements are bolstered by the fact that the residual mechanism is founded on normative continuity with the ICTY and the ICTR. The residual mechanism continues the jurisdiction of both tribunals, imperative both in the context of bringing the remaining ICTR fugitives to justice and in providing an ongoing supervisory jurisdiction for those who have been convicted and sentenced by the tribunals. This brings me now to highlight some of the most important features of the mechanism. My office, in close collaboration with the ICTY and ICTR, prepared the Secretary-General's report that informed and assisted the Security Council's informal working group on international tribunals during their 4-year deliberations on the establishment of the mechanism. Although the administrative and operating structure of the mechanism differs from the existing tribunals, their strong influence can be seen in, for example, the mechanism's statute and its rules of procedure. It, however, is a much smaller and leaner body, which will expand as required, for example, upon the arrest of one of the remaining ICTR high-level fugitives. The Secretary-General's report identified a number of core functions which the mechanism would be required to perform, including the trial of fugitives and contempt cases, the protection of witnesses, the review of judgments, the referral of cases to national jurisdictions, the supervision of enforcement of sentences, the provision of assistance to national authorities, and the management of the archives. It's clear that some of these functions will generate work on an ad hoc basis. For example, if a fugitive is arrested, whereas others will require ongoing day-to-day work, for example, the management of the archives. The ongoing protection of witnesses is, I believe, one of the most important functions which the residual mechanism will perform. The landmark decisions which have been delivered by the ICTY and the ICTR, and the historical record which has been created by their proceedings, would not have been possible without the bravery of hundreds of victims and witnesses who have come forward to tell their stories. Their continued protection may at times rely upon the existence of a contempt jurisdiction before which proceedings can be brought. And the importance of this function cannot be underestimated. As we mark the opening of the Hague branch, we have the benefit of the experience now of 2 decades of work of the ICTY and ICTR. This experience makes clear that the work of the mechanism will not be performed without its challenges. And I think it's worth noting some of those challenges today. I've already highlighted that the residual mechanism is a leaner structure than other tribunals, which will of course have considerable benefits in terms of efficiency and cost saving. However, it remains to be seen how, in the event of the capture of a remaining high-level fugitive, the capacity of the residual mechanism will expand in practice. I'm confident that in such circumstances, the staff of the mechanism and those lawyers and judges who appear on the roster will rise to the challenge and will facilitate smooth and expeditious proceedings in keeping with the highest standards of international justice. The continued cooperation of member states remains vital for the successful performance of many aspects of the work of the mechanism, ranging from the arrest and detention of remaining fugitives to the ongoing protection and relocation of witnesses, whose essential role I've already highlighted. I trust that the international community will maintain its commitment to cooperating with the mechanism as an integral element of the international criminal justice framework. A commitment to accountability requires that efforts to locate the remaining ICTR fugitives and to bring them to justice continue. A commitment to justice requires that those who have been convicted by the ICTY and ICTR have access to proper judicial supervision of their sentences. And a commitment to the creation of a lasting historical record requires that the archives of the tribunal be properly preserved and maintained, and that appropriate access be facilitated. The challenges which will be faced by the mechanism pertain not only to it as an institution, but also as a part of the architecture of international criminal justice. I've described some of the advancements which have been made in the past 2 decades, so many of which are attributable to the work of the ICTY and ICTR, but much remains to be done. Having made a commitment that there will be no impunity for those who commit serious international crimes, The international community must ensure that the institutions charged with bringing perpetrators to justice have the resources, financial and otherwise, to do so. The establishment of the ICC was a pivotal moment in international criminal justice, but it too has faced some considerable challenges. Although today 122 countries are states parties to the Rome Statute, and the Court enjoys the firm support of many countries which are not states parties, and although the number of states parties continues steadily to grow, universal ratification of the Rome Statute is still a long way off. Large parts of the world remain outside the Court's scope, and we remain some way from full compliance with the obligations by those states who are parties to the statute. The ICC relies upon member states to protect, to provide it with evidence, to enforce warrants of arrest, to protect and relocate witnesses, and to enforce sentences. Unfortunately, for example, there have been instances in which member states have not complied with the orders issued by the court, and individuals who are the subject of arrest warrants have travelled with relative freedom in certain jurisdictions. So finally, I'd like to conclude by highlighting what we believe some of the critical lessons have been drawn and can be drawn from the UN's work to end impunity for international crimes. Firstly, it's clear the old era of impunity is over. In its place, slowly but surely, we're witnessing truly the birth of a new age of accountability. Secondly, in this new age of accountability, nobody is above the law, including in particular heads of state. Leaders will eventually be held accountable for their actions. Thirdly, sovereignty as a barricade against international justice is gone. And finally, the obvious: there is no peace without justice. Peace and justice must go hand in hand, and elements of justice must be factored into every post-conflict strategy in order for peace to be sustainable. In each of these lessons, we can identify the imprint of the work of the ICTY and ICTR. The legacies of these tribunals are truly remarkable, and I'm confident that they will be preserved and strengthened by the residual mechanism. The strong element of continuity between the ICTY and ICTR and the mechanism sends an important message to the accused whose cases have not yet been completed, to the fugitives from the ICTR, and, importantly, to would-be perpetrators of atrocities more broadly, that the international community remains committed to the pursuit of accountability and will not tolerate impunity. No one can outlast international justice. I wish the staff of the Hague branch of the mechanism every success as its operations commence. I'm confident that the transition from the ICTY will be smooth, and that this newest institution in the field of international criminal justice will, with the resolute support of the United Nations and of the international community, succeed in its work. Thank you, President Moran. Thank you very much, ladies and gentlemen.
Thank you very much, Mrs. O'Brien. For our next speaker, I am happy to welcome the prosecutor of the ICTY, Mr. Serge Brammertz. May I invite you to the podium.
Good morning, everybody. It's nice to welcome you back to the tribunal, to welcome back many friends and colleagues who were here a few weeks ago when we had the 20 years anniversary of the tribunal. As one chapter of the ICTY's life closes, a new one begins with the commencement of the Hague branch of the MICT. I wish the MICT principals good luck with their work and extend to them the full support of my office as they begin their journey. I have no doubt that they will find within the ICTY a wealth of talent to fill the ranks of the MICT Hague branch. Other speakers today will focus more on the MICT and its work, and I don't want to repeat what they say. So instead, I would like to share with you very briefly some more general thoughts on international justice and the challenges ahead. Several weeks ago, I had my annual meeting with the foreign correspondents in the Netherlands. And it was the usual briefing where I spoke about the ongoing cases, about the completion strategy, about the cooperation with the regions, and of course, what the remaining challenges are. And at the end of this discussion, I was somehow taken by surprise by the question, prosecutor, do you still believe in international justice? And after a few seconds of hesitation, my answer was, yes, I do. But I also said that my belief had not grown much stronger in the 10 years since I started working in the field of international justice. And as always with journalists, if you say too little or too much, I was asked to explain my answer. And my message was, yes, of course, I still believe in international justice. Why? Because I don't want to live in a world where there is no accountability for atrocities. I don't want to live in a world where political and military leaders can abuse their power at will to murder and traumatize thousands, turn neighbors against each other and destroy communities. And I don't want to live in a world where people whose lives have been torn apart by evil crimes are left to suffer in silence with no redress. But I also explained that I don't believe international justice had grown much stronger over the past 10 years because today we still face many challenges that undermine our confidence in the international justice system. At the top of this list of challenges are the hurdles faced in arresting fugitives, and it was mentioned before by my colleagues. This is currently one of the ICC biggest problems, with some 10 fugitives currently at large. The ICTR, almost 20 years after its creation, still experiences similar difficulties. And then there is a special tribunal for Lebanon, where trial in absentia looks certain because the fugitives remain at large. Our inability to bring accused persons into custody not only weakens international justice, but also negatively impacts on the international community's credibility. And while the ICTY stands out as a positive example on fugitive arrests, we must accept that we are facing other challenges. In particular, we risk undermining our many important achievements unless justice in The Hague is meaningful and understood by the victims and the community in the region and internationally. This is especially important when the tribunal's decisions are controversial. So my wish for today is that we use the opening of the MICT in The Hague to think harder about closing the gap between The Hague and the countries in the former Yugoslavia by bringing justice closer to the survivor communities. We must do this through effective dialogue, active communication, and openness to critique on the tribunal's work. I'm confident that on this issue too, the ICTY and now the MICT can still set a positive precedent for international justice in the future. Thank you very much.
Thank you, Prosecutor Brammert. It is easy to use terms like groundbreaking and pioneering to describe the ICTY today. But 20 years ago, when the tribunal was established, it was little more than the kernel of an idea, an institution that existed on paper and nowhere else. We should never forget the challenges faced in making the Security Council's vision for the first truly international criminal tribunal into a reality, and the difficult questions the tribunal's principals, judges, and staff had to address. What rules of procedure and evidence were required by an institution that sought to meld together different legal traditions to conduct trials and appeals, the likes of which the world has not seen in nearly a century? What practical processes and resources were required to run a functioning criminal court operating in a multitude of languages. How would witnesses be brought to The Hague to give testimony? How, for that matter, would witnesses and possible victims be identified in the first place? And more importantly, how could and would the tribunal assure their protection, to encourage them to come forward and let their voice be heard? These, of course, were not the only challenges the tribunal faced early on. Buffeted by criticism from many sides, the tribunal struggled to elicit the cooperation from states, which is so vital to the functioning of an international criminal court. Vital not only in obtaining documentary evidence and conducting investigations, but to the fundamental issue of locating, arresting, and transferring indicted individuals to the tribunal so that they may stand trial. Without police powers, the tribunal faced challenges in asserting its authority to issue orders requiring state compliance. And without a separate judicial infrastructure on which it could rely, or a prison system of its own, the tribunal had to construct legal aid schemes and find solutions for how and where its sentences would be enforced. The fact that the ICTY has succeeded in finding innovative and effective solutions to all of these challenges and many more is a testament to the tremendous integrity and dedication of those judges, prosecutors, registrars, and staff members who served so ably the tribunal during its early years. And it is a testament to the commitment of our host state, the Netherlands, and to the many other members of the international community whose ever-increasing cooperation and support have helped to bring the Security Council's vision for an ad hoc international criminal tribunal into reality. The mechanism, as it commences its operations here at The Hague today, does not face the same challenges that the ICTY confronted in the early years. This is not only because the mechanism can look to the ICTY and the ICTR as models for its own operations. It is also, and more importantly, because the mechanism is able to turn to and to rely upon the people behind these institutions, the principals, the judges, and the truly phenomenal staff, and to benefit from their experience and expertise. Indeed, we are truly fortunate that the great majority of the mechanism's own staff have joined us and will join us from either the ICTY or the ICTR. To be sure, the mechanism is a different type of institution than either of its forerunners. It is, by design, quite small and lean, mandated to undertake a limited number of core functions previously carried out by the ICTY and the ICTR. Its judges, with one exception, do not work for the mechanism full-time. While the mechanism will hear appeals, if any, in certain ongoing ICTY cases, it is expected to have a very limited caseload going forward. The mechanism, in short, will never be the lion on the international stage that the ICTY has been. But the mechanism, nonetheless, has a tremendously important role to play. It is here and will continue to be here to ensure that vital protective services continue to be provided to victims and witnesses, that the evidence gathered by the first two international criminal tribunals of the modern age will continue to be available to national authorities and others as appropriate, and that those individuals who have been convicted by the ICTY or the ICTR will have an institution to which they may address in the future petitions for early release. The mechanism is here to ensure that the closure of the ICTY and the ICTR in the years ahead does not open the door to impunity for those fugitives indicted by the ICTR who have yet to stand trial and whose cases have not been referred to national jurisdictions. The mechanism is here to ensure that appeals still to come will have a place to be fairly heard, that requests for review of judgments may be determined, that the responsibilities of both the ICTY and the ICTR with regard to the accused and the convicted, the victims and witnesses who have come before them over the past 20 years will continue to be met. The tides of public opinion may shift and sway, but the foundations built by the ICTY and the ICTR and the modern approach to international criminal justice remain unshakable. These two tribunals have demonstrated that a shared commitment to accountability can and will win over impunity, that heinous crimes can be punished, whoever their architects may be, and that principled justice, fair and impartial justice, is the only way to uphold the law. It is on these strong foundations that the mechanism itself can rise now up and take its place among the international institutions here in the international city of peace and justice. In my role as both the president of the ICTY and the president of the mechanism, I thank you all for joining us to mark this special occasion today. I, of course, am not the only one who serves two institutions at once. Mr. Hassan Boubacar Jallow, our next speaker, serves ably as both the prosecutor of the ICTR and the prosecutor of the mechanism. I now call on upon Mr. Jallow to deliver his remarks.
Honorable President of the ICTY and the MICT, Honorable Minister, the Lord Mayor of the City of The Hague, His High Excellency, the Legal Advisor to the United Nations, Your Honors, Mr. Prosecutor of the ICTY and the Registrar of both the ICTY and the MICT, distinguished guests. Today marks another milestone in the evolution of the process of international criminal justice with the inauguration of the Hague branch of the International Residual Mechanism for Criminal Tribunals. 1 year ago today, we witnessed the official opening of the Arusha branch of the mechanism in Arusha, Tanzania, and I'm happy to report that the OTP in that branch itself is now fully operational with a full complement of staff and has been actively pursuing the implementation of its mandate since the 1st of July 2012. The opening of the Hague branch today will usher in the second and final phase of the establishment of the mechanism, a mechanism that is mandated by its statute to continue the functions of the ICTY and the ICTR and during the period of its operations, and in this respect, take over and continue the material, territorial, temporal, and personal jurisdiction of the two tribunals. Thus, from its establishment, the Office of the Prosecutor of the Hague branch will be engaged in both ad hoc as well as core activities, continuing core activities. The former will comprise the management of all appeals where the notices of appeal have been filed on or after 1st July, that is today, 2013. Unlike the Arusha branch, which has 3 outstanding fugitives earmarked for trial in Arusha, the Hague branch of the OTP of the Hague branch has no fugitives outstanding and will not therefore undertake trial work except in respect of possible retrials and perhaps in respect of contempt trials. The core activities of the single OTP of the 2 branches are, however, similar and will comprise, among other things, the management of archives, legal assistance to and capacity building in national jurisdictions, enforcement of sentences, management of review proceedings, witness protection, etc. The recruitment of the core staff of the Hague branch of the OTP is actively underway, with some of the staff already in place as of today. And I expect that all of the core staff, numbering just about half a dozen, will be in place shortly. We are already making announcements for the recruitment of the members of the ad hoc teams of the Hague branch who will be responsible for the management of the appeals which may come under the jurisdiction of this branch. And I would like to encourage all members of staff of both the ICTY and the ICTR to consider putting in their applications when these announcements are made. The establishment of the mechanism is indeed a truly historic occasion, marking as it does the conclusion of an important phase in international criminal justice, with the imminent closure of the 2 main ad hoc tribunals, that is the ICTR and the ICTY, and in a very innovative and cost-effective manner, ushering in another phase. It is also, however, a challenging process, presenting challenges to both staff and management, and indeed to the constituencies of the ad hoc tribunals. Nonetheless, the operations of the Arusha branch of the mechanism for the past 12 months have demonstrated that these challenges can be overcome. The process of ensuring accountability for international crimes continues, albeit in a lean but very effective and very efficient manner. The phased establishment of the 2 branches of the mechanism, with Arusha starting off first last year, should enable us to take advantage of the lessons learned from the establishment of that particular branch. The mechanism will rely, for the success of its mandate, on the support of the existing tribunals in many respects, on the double-hatting of staff, on the commitment of management and the provision of support services by the administrations of the 2 tribunals, and the dedication and the competence of its small number of staff. Above all, on the cooperation of member states of the international community. I remain confident that this support will be available and that the Hague branch, like its counterpart, the Arusha branch, will take off and execute its mandate effectively. The states of the former Yugoslavia will continue with the focus of capacity building as well as the sharing of information that is held by the OTP of the, currently by the OTP of the ICTY. In May of this year, upon the invitation of the State Attorney General of the Republic of Croatia, I was able to pay a first official visit to the region as prosecutor of the mechanism to attend the 7th Regional Conference of Prosecutors of States that made up that former country. Naturally, local prosecutors from all the states were interested to learn about the future of mutual legal assistance and the continuing transfer of information and expertise to support local prosecutions. I wish to reassure them that the establishment of the Hague branch of the mechanism will mark a jurisdictional change, but our partnership with national authorities in the region will continue on matters of legal assistance, on capacity building, and the various other projects that already exist between them and the OTP of the ICTY. And in this respect, I would like to thank our international partners with special appreciation to the European Union for its unflinching support to the ICTY and particularly to OTP over the years. And I look forward to that continuing cooperation and partnership between the Union and the mechanism. One of the biggest challenges that the mechanism as a whole faces is the tracking and arrest of the 3 remaining fugitives indicted for genocide and related crimes by the ICTR. Felicien Kabuga, a former businessman and director of the infamous Milcolin, Radio Milcolin, Protem Piranya, former commander of the Presidential Guard, and Augustin Bizimana, former Minister of Defense of Rwanda. They are all charged with playing a leading role in the most serious crimes under the law and in the context of one of the worst humanitarian tragedies of modern times. Justice and peace in the region require that they be arrested and held to account for their roles in the 1994 Rwandan genocide. The mechanism, which has jurisdiction over their cases, will continue to pursue their arrest vigorously. But we need the support of all states if we are to succeed. And on this occasion, I would like to seize the opportunity to reiterate our call on all states to live up to their legal responsibility of cooperation with the mechanism. For those states in which the fugitives are suspected to be hiding, to conduct vigorous and credible efforts to arrest and transfer them to the mechanism. And for the other states, to provide the necessary support to this process in all ways that they can. And I believe it is only in this way that the international community can bring some real closure to the process of accountability for the international crimes committed in Rwanda in those dark days of 1994. There are many I would like to thank today, the government and people of the Netherlands and the city of Den Haag for being our hosts, the Honorable Her Excellency Patricia O'Brien and her staff of the Office of Legal Affairs, who have been behind the conception, the design, and indeed the nursing of the mechanism, not only of the mechanism, but indeed of all the ad hoc tribunals which have been created in order to ensure that violations of international criminal justice do not go unpunished. To all the staff of the ad hoc tribunals who, through their work, their dedication, and their competence, have demonstrated that international criminal justice is a viable and necessary option and have given us the confidence to move forward to more permanent arrangements. Finally, to my dear friend George Theodore Meron, President of the ICTY and President of the mechanism, and to the Registrar John Hocking, who is also double-hatting as Registrar of both institutions, and to my friend and colleague, the Prosecutor of the ICTY, Serge Bramets, who have all demonstrated their leadership role in moving forward international criminal justice, making it an important element in the international arena today, and who have also given much of their time and their energy, as well as those of their staff, in ensuring that the mechanism takes off today as scheduled. I thank you all for your attention.
Thank you, Prosecutor Jallo. The final address in our program today will be delivered by my colleague, Mr. John Hocking, the registrar of both the mechanism and the ICTY. Mr. Hocking and his staff, both in Arusha and here at The Hague, have done so very much to ensure that as the mechanism opens its second branch here at The Hague, everything goes smoothly. I am tremendously grateful to him and to his staff for all that they have done and for all that the registrar staff supporting the ICTY continue to do for our tribunal on a daily basis. Mr. Hocking.
First, thank you very much, President Meron, for your kind words, and I thank you, On behalf of the staff, as well as myself, I'm very grateful for your appreciation. Excellencies, distinguished guests, colleagues and friends. On a brisk evening in January last year, I received a phone call from New York. The Secretary General had chosen me to become the registrar of the mechanism. I accepted without hesitation. I was impatient to start up the newest of international criminal institutions. Much to my surprise, however, my enthusiastic response earned more looks of apparent bewilderment than words of hearty approval. What else could the mechanism possibly do, some asked, after the ICTY and the ICTR had already impressed in academic books and in the public's consciousness that impunity for war crimes and genocide is no longer free to reign. What could possibly be challenging in preserving this irreversible legacy? And after having managed over 1,000 people at times of recruitment and at times of downsizing, how could it be professionally gratifying to administer less than 100? Far from craving a cushy job, I recognized the mechanism as the challenge that it is. I saw it as the opportunity that it should be. The conclusion of the remaining cases before the ICTR and ICTY does not mark the end of the support of the international community, the toil of thousands of staff, the waiting of victims. More lies ahead. The tribunal's work must be preserved. The last fugitives must be arrested, and justice must run its course. I see the mechanism as our opportunity to meet the challenges that the tribunal's legacy do not fall into oblivion, but live on in the actions of tomorrow's leaders. And I see the mechanism as our opportunity to meet the challenge that international criminal justice is not only fair, but also delivers with greater efficiency and less resources, so that in the future other courts may take a leaf from the mechanism's book, as they have previously done from the tribunals. Small and efficient in the vision of the Security Council that created it, the mechanism has no shortage of responsibilities. The mechanism is the custodian of the largest archives of the crimes which engulfed the Balkans and Rwanda, thousands of testimony and hundreds of thousands of video recordings of historic proceedings, photographs of mass graves and perpetrators' diaries depict indelibly the atrocities that stained churches and farms and stadiums and public offices. If not preserved and if not made accessible, this unparalleled collection will not serve its purpose to remind and to teach. More and more, domestic jurisdictions, near or far from where the crimes occurred, perpetuate the tribunal's work in their courts. Their efforts are a tangible sign that the fight against impunity does not end with the tribunals, but continues with their national borders and beyond our statutory boundaries. These courts deserve applause and encouragement. At the mechanism, we strive to build their capacity and provide them with technical support. The tribunals would not achieve justice if the persons they convicted did not serve their time, but it would not be justice we can be proud of if their prisoners' rights were violated. The mechanism vigilantly watches over both, that sentences are enforced and that convicts are treated with that fundamental respect pertaining to the inherent dignity and value of all human beings, even those who have found their souls tainted with the world's most shocking crimes. Excuse me. Nearly 10,000 witnesses from all walks of life, but mostly ordinary women and men of humble origins, recounted to the tribunal's judges and to the world the speeches they heard, spreading hatred and inciting violence, the corpse they saw, disfigured from the mass graves yet strikingly familiar, and the wounds they felt, still tormenting their bodies and hearts 20 years later. Their support and protection continues in the capable hands of the mechanism's witness specialists. 1 year ago, the mechanism opened its doors in Arusha, and since its first day, the registry has worked to the highest international archival standards, served national jurisdictions, inherited the enforcement of ICTR sentences, and continued to protect its witnesses. The provision of these services could suffer no gap in their transfer to the mechanism, and no gap was suffered. In the appeals and contempt matters before the mechanism, the registry has provided all necessary support to the judges and to the parties, be it by ensuring that the indigent accused have access to highly qualified defence, or developing governance documents to translate into the daily court work the ideal of fair and efficient proceedings. The mechanism will count on the same support when Kabuga, Bizimana and Priyanya are finally brought to justice, and 0 fugitives will be etched on the mechanism's wanted list like it is today on the ICTYs. With the ongoing vital support of the ICTR and the ICTY, for which I am profoundly grateful, we designed lean administrative infrastructures, we offered cutting-edge services, meticulously recruited some 60 staff of 28 nationalities from Albania to Zimbabwe, blessed with a variety of talents and a shared resolve to make the mechanism a success. With no existing instruction manual, but driven by an ambition to achieve, not only has the mechanism Arusha branch preserved the attainments of the ICTR, but it has built on them, enhancing the efficiency of its operations. 1 year on, and 1 branch into the job, the first results are already visible. More will follow, starting from today, as the mechanism reaches its full strength. Whether we draw this resolve from the mechanism's founding documents, or the ever-increasing calls for a more expeditious and less onerous international justice, whether we are called to it inspired by the indefatigable strength of the survivors, our renewed commitment and sharpest creativity will once again further the advancement of international criminal justice. Thank you very much.
Thank you very much, Registrar Hawking. This concludes our formal program. I wish to extend my thanks once again to our speakers who joined us today, in particular Minister Obsterten, Mayor Van Artsen, and Mrs. O'Brien. I would also like to express my gratitude to all of you in the audience for joining us to mark this occasion. And I encourage you all to stay and join refreshments and company of colleagues and friends. Thank you very much.